Good afternoon, everybody, and thank you for joining us. I'm John Phillips, the partner in charge of Jones Day in London, and I'm joined by a number of my partners here in London and across the rest of Europe. Our aim for the next hour or so is to summarise the principal legal issues that we see arising from the result of the UK's Brexit referendum. There's a lot to get through. Because we're a global firm, many of the people on this call will be from outside of the EU, so we thought it might be helpful if I set the scene a little. Last Friday's result came as a shock to everybody. The financial markets, the pollsters, the bookmakers were all calling it for Remain when the polls closed on Thursday night. No one was more surprised by the outcome of the vote, actually, than the leaders of the Leave campaign. Nigel Farage had even conceded defeat immediately after the polls closed. And after last year's fiasco around the advanced polling of the UK general election, this has been another serious failure for the polling industry and the predictors. When it came to the result itself, only London, Scotland and Northern Ireland voted to stay in. The young wanted to remain, the over 60s wanted to leave. There was a similar split on socio-economic lines, and the vote was seen by many as a protest against the governing elite and the establishment. And that, of course, is the dynamic that we're seeing in other parts of Europe and, of course, in the United States. The vote has therefore created not only division but also a political firestorm here that's impacted on the rest of the world. We have a lame-duck Prime Minister, albeit a dignified one, who is now attending his last ever summit of the EU in Brussels, but who will shortly be departing. And we have an opposition leader who refuses to step down, even though his own members of Parliament yesterday gave him a resounding vote of no confidence. It's looking almost inevitable that there will have to be another UK general election soon. But now that the shock is wearing off a little, the question is, what happens next? The reality is that we're in the early stages of a painful separation in which neither side is really talking to the other yet. Indeed, no one knows who is going to be doing the talking from the UK side, or how long the separation process is going to take. Indeed, the biggest problem is that no one actually knows what Brexit will look like in practice. And that's because the UK now has to redefine the terms of its relationship with the EU. And there are a range of possibilities, from a complete and acrimonious divorce, which is considered to be unlikely, to other forms of quasi or almost membership. We could, for instance, with the agreement of the EU, remain a member of the single market, the so-called Norway solution, but that would likely require the UK to accept full freedom of movement, which was such a contentious issue in the referendum debate. In any event, the UK, in order to get all of this started, needs to file a formal notice under Article 50, which will begin the 2-year negotiation period. And at the end of that, the UK's membership of the EU will come to an end. The UK hasn't given that notice yet, and certainly won't do so until a new Prime Minister and government are in place. And the EU has made clear that there won't be any preliminary talks before that notice. So, as things stand, it's effectively stalemate. So as you can see, the answer to the question, what happens now, is almost exclusively a political one. But until the UK leaves the EU, with whatever arrangements are negotiated as part of that process, we do know that the legal environment will remain exactly the same as it was before. Nevertheless, our clients are rightly focused on the challenges and opportunities presented by the results of the referendum and are trying to create an idea of what a post-Brexit environment will look like. They're seeking to understand the implications of Brexit in whatever form it may take so that they can plan accordingly. So on today's call, we plan to cover what we believe, based on questions that have been posed to us by our clients in the 6 days since the results, are the principal areas of interest from a legal perspective. Those areas include, obviously, the effect of a Brexit on English law, the regulatory environment, and issues such as employment and tax. Because there's so much to cover, we won't be taking questions during this call, but if you do have any specific questions during the session, please feel free to use the Q&A facility on the webcast website, and we will respond to them afterwards. And as things become clearer, we'll be updating our clients both individually and through materials that we'll put on that website. And we're also going to do more detailed webcasts on various of the key topics. So, turning then to each of those various key issues, I want to start off with probably the most obvious one. English law is considered to be one of the most important legal systems in the world and is used widely to document transactions and settle disputes all over the world. Adam Brown, who does an awful lot of international litigation, is that going to change? Is the primacy of English law going to be affected?
Well, John, this is a fundamental issue not only for us here in London, but obviously the English legal framework is one that's predominantly used for cross-border transactions. And thankfully, there's a straightforward answer, and that is that the fundamentals of English contract law and the reasons for parties choosing it are entirely unchanged by the Brexit referendum. So whilst there are a host of uncertainties which you've referred to post that referendum, there's going to be no dramatic change to how the English courts, or indeed the EU member state courts, will treat English law-governed contracts. So no, commercial parties shouldn't have any concerns on that front. And that certainty is one of the main reasons why English law is chosen for a good proportion of those cross-border transactions. And there are several factors that feed into the certainty. There's firstly the robust statutory framework which we have, supported by a strong body of case law developed over the centuries. There's a legal market which is mature, and that's not just in London, but again, that's in the other markets in which English law operates. And a judiciary that's globally recognised as reflecting commercial common sense and business pragmatism when it comes to issues of construction of contracts. And as I see it, none of these factors are impacted by the referendum decision or even by any EU exit. And I'd be really surprised if anyone on this call had chosen English law because of the UK's membership of the European Union. I just don't see the connection. And then just one final point, John, as you were mentioning the ultimate negotiation of any exit or outcome. The UK government openly champions the export of English law and celebrates London as a centre of litigation tourism. So as I see it, in any negotiation, it will be keen to avoid jeopardising that very important revenue stream.
Okay, sorry Adam, can you just enlarge on what you mean by litigation tourism?
Yes, absolutely. I mean, London sees the resolution of disputes by a multitude of parties, which at first blush, there is no necessary nexus with the English jurisdiction for those disputes, but it's because of those issues that I was addressing, such as certainty, the quality of the judiciary, that means that they choose England as a forum for resolution of those disputes.
Okay, but if we are outside of the EU, if the UK is outside of the EU, how will that affect the enforcement of judgments from the English courts in EU jurisdictions?
Well, in terms of, I guess there's two issues. There's arbitration awards, which emanate from England, and those are not going to be affected in any way because of the international convention which governs those. And then if you're talking about taking an English court judgment to Europe, or conversely bringing a European judgment to the UK, There is an extremely streamlined system in place at the moment. We don't know what the next regime is going to be, but at most we see it as being slightly less straightforward, but still relatively simple, perhaps with a little more time and cost involved, but nothing more.
Okay, but there are other conventions that regulate the point? Absolutely. Okay. All right, thanks, Adam. I'd like to turn it over now to one of Adam's litigation colleagues, Harriet Terrett, who plays an important part in our litigation analysis of contracts, so looking at litigation risks at the front end. And again, Harriet, is there anything that you think companies ought to be looking at when they look at their suite of contracts? Is there anything about the terms of those contracts with which they should be concerned after a Brexit?
Well, I think everyone on this call has to live in the real world and acknowledge that just because, as Adam says, an English law contract means exactly the same today as it did last week, doesn't mean that there isn't an increased risk and that someone isn't going to try and challenge that. In terms of what the issues actually are, I think we have a very clear blueprint to look at, which is the impact of the bankruptcy of Lehman Brothers in 2008. Now, to be clear, I am not suggesting for one moment that the outcome of the UK referendum is on a par with the 2008 financial crisis. We all lived through it. None of us want to go back there. But if you look at the market reaction, if you look at share prices, liquidity, if you're someone that has to analyse business risk generally, there are some very clear parallels. So I think the issues that will come up will be pretty similar to what we saw in Lehman. That means three general categories. First category, an actual Brexit dispute. Someone relying on a clause or a material adverse change clause, or simply saying this contract can no longer operate post-Brexit. None of those are straightforward claims to bring. The possibility of Brexit has been out there for quite some time, but we saw those types of claims in 2008, and I think we will see some of them again in future. Second category, where we're seeing a lot more immediate questions, are around market volatility. The movement in the market affects financial contracts. It particularly affects the types of contracts that international corporate groups enter into, whether it's hedging or whether it's security. And we also shouldn't forget that 30th of June, tomorrow, is going to be a loan covenant date for a lot of those international groups. And then there's a third category, which I'm somewhat cheekily going to call the buyer's remorse category. Contracts that looked like a great deal last month may not look quite as good now. One thing we saw a lot of post-2008 was people going back to contracts, looking at documentation, looking for errors, looking for unconnected defaults, and trying to find ways to leverage for negotiations or actually even challenge those contracts. So, for those people on the call who are looking at forward business planning, I think exactly the same mantra applies as it did in 2008. Know your contracts, know your boilerplate, particularly your notice provisions or your waiver provisions, and make sure that you are hitting those commercial requirements in a clear and unequivocal way. So for me, it's those three things: a small risk of real Brexit issues, a bigger risk of sort of market volatility issues, and everyone just needs to make sure they're operating their contracts in accordance with their terms. Okay, thanks, Harris. And of course, buyer's remorse is an expression that we've been hearing a lot about recently because it's an emotion that's been attributed to the many people who have perhaps voted leave without ever expecting it to actually happen. So there you go. Michael Pabst leads our banking practice here in London, and before we move off contractual considerations, Michael, your view, I believe, is that we're not going to see a great deal of obvious change to banking and finance documentation. Is that right?
That's right, John. I think our consensus view here is that, as with any other contract, loan documents will remain enforceable regardless of Brexit and what may happen in the future. It's therefore very unlikely that banks or borrowers will want to change existing documents for purely legal reasons. And the LMA, which is the peak body for loan documentation, announced this week that it doesn't see any changes in the immediate future in connection with their standard terms, which most borrowers would use for borrowing money. There may, however, be some changes for economic reasons, for example, the underperformance of borrowers due to the changing economic environment. And Harriet mentioned a second ago that we do have a covenant reporting date coming up shortly that may be relevant. And we have further covenant reporting dates coming up, typically in September and December as well. On new loans, there may be some changes, particularly to the initial documentation, where lenders may look to beef up the so-called flex clauses that allow them to change terms and conditions once the syndication is in process. And that'll just follow as an automatic result of the uncertain economic environment we're in. But generally, it seems that things will be business as usual from a documentation point of view.
Okay, so no change there. Okay, I'd like to stay on the banks and the financial sector because that's, in many ways, one of the best examples of where we're going to have to find a negotiated solution to the way that regulation is going to work going forward. John Ahern lives and breathes financial regulation and writes exclusively on it. He loves this stuff. A lot has been written about banks and other market participants perhaps moving staff out of London. I'd like you to talk about that, if you may. And also, can you explain the whole question of how US and other overseas firms might be looking to passport into the single market from London?
Sure, John. Well, as you said at the outset, we're just in the wake of this vote. We have a long way to go before there's any clear idea of what Brexit will look like going forward. There is a range of options from, as you said, John, membership of the EEA, in which case there's unlikely to be any significant regulatory change, or an absolute isolationist position in total exit from the European Union, in which case there will be some regulatory repercussions that firms operating from here will need to think about. But let's not forget that in advance of understanding how all of this will unfold, notwithstanding the press reports, it is premature to make decisions as to where you're going to structure your operations or where you're going to move staff. The reason that international and US banks are in the London market is because it is consistently ranked as the either number one or number two financial market in the world. Many of them come here not just to operate from London as a hub into Europe. Some of them come here for access purely to the infrastructure of the UK market. But undoubtedly, firms will need to be thinking about, as the story unfolds, how they are going to review their business models going forward and how they're going to adjust to the new situation. But suffice it to say that access to the European single market will continue to be of importance to numerous international firms operating from London. And even if we take the step of having an isolationist stance from Europe, i.e. a total exit, which I think many commentators feel is unlikely, then even in those circumstances, the architecture of more recent European regulatory measures is such that as long as there is an equivalence decision by the European Commission on the quality and nature of home state regulation, then third country firms operating from London can equally access particularly the institutional and wholesale markets in the rest of Europe. So in other words, there is this third country passport availability under regulatory measures such as the Markets in Financial Instruments Directive number 2, which will come into force on the 3rd of January 2018, and other directives such as the Alternative Investment Fund Management Directive, which really regulates European operations of private equity, real estate, and other alternative fund providers. But the point is that it's not true to say that firms operating from London will no longer have access to the single market by reason only that Britain exits, provided that equivalent decision is made by the Commission. Now, I think that it would be inconceivable that an equivalence decision would not be forthcoming in the event of a total Brexit on the basis that all of our laws and regulatory framework will be entirely consistent with EU standards as at the time that we might leave. I appreciate, however, that there's likely to be some political jostling for a share of the prize of the London market as it stands today. And it might be that certain members of the European Union who might inform Commission views, not least Ireland, perhaps France, Germany, all with substantial financial markets in their own right, might take a different view.
Okay, that's very helpful. And on that last point, we also have colleagues from Paris and from France and Germany on the line, and I'm going to put that similar question to them when we finish with John, so that we just get a French and German view on that very obviously important issue. John, despite your love of financial services regulation, you're always kind of commenting on how much there is of it to keep up with. The so-called forest of regulation. If there is a Brexit and the UK leaves the EU, do you think we're going to see less financial services regulation here, or is there going to be a bonfire?
Well, it's certainly true that I do have a love of regulation. Certainly there's a lot of it to love. I think that irrespective of what the final outcome is, we are likely to see regulatory change to a greater or lesser extent. If we move towards the extreme of a total exit, then that is going to involve a substantive review of the regulatory framework. In particular, a range of measures introduced under EU law have been implemented by way of what we call directly applicable EU regulation. In other words, they are legislative measures emanating from Europe that do not require transposition into domestic law. So to the extent that we would entirely leave Europe, all of those measures would need to be looked at afresh, and there would obviously be a need to fill the legislative vacuum that's likely to arise. I should say, however, that a number of the measures that we have in the regulatory field post-financial crisis are largely driven by aspirations and resolutions of the G20 and other international organizations, and so that I do not expect that in substantive terms our regulatory provisions will diminish entirely. There may be some areas where the UK might take a lighter touch approach than perhaps Europe would in similar circumstances. But going back to the question of equivalence, we are going to have to be mindful of ensuring that in order to have access hopefully to the single market, that we are able to meet the equivalence requirements of the EU authorities.
Okay, thanks, John. And on that note, I'd like now to go over to Paris in France and Alban de Caillemet-Duffarage, who is the leader of our banking practice in Europe. Before we get on to that general question, Alban, and so before we speak about equivalence and the jostling that that John described, you and I have spoken on a number of occasions in the past few months about the new EU directive, which looks to prevent bank insolvencies in Europe. What might the effect of a Brexit be on that proposed legislation?
Indeed, John. One of the three pillars of the new banking union is the bank resolution regime, which is applicable to all banks and investment firms in the EU. In short, resolution is all about avoiding, as you said, banking insolvency or nationalization at a taxpayer's cost. And this is due to be achieved pursuant to a European directive of 2014 known as BRRD, which gives broad powers to resolution authorities in every member state for notably declaring a 24-hour stay on all liabilities of a bank, or bailing in or transferring all its contracts or entire business divisions to third parties, with very limited rights for shareholders or creditors to oppose. BRRD contains provisions designed to ensure that such powers have extraterritorial effect beyond the borders of the Union. Upon a Brexit all agreements entered into by European banks and governed by English law will need to be treated for the purpose of BRRD as third country arrangements. In practice, this means that all such contracts will need to be amended to include contractual recognition by the counterparty of European resolution proceedings. But reciprocally, we may anticipate the same to be requested by the PRA, the English prudential regulator, in respect of contracts entered into by English banks and governed by EU law. So you see, John, this is exactly, or a perfect illustration, I would say, of the sort of issues that in the common interest of all parties would be best dealt with through mutual recognition agreement between the UK and the Union.
Okay, that's great, Alban. So on that basis, how then do you see these discussions or suggestions about there being perhaps tension between the banking industries in say, the UK, France and Germany over how we take all this forward?
Well, maybe just focusing on the point that John has just made, and I think I cannot agree more with everything he said, and I think that we're hearing a lot of silly things about the effect of losing the passport. I would just maybe add a couple of things to what John just said. First is that the framework that he describes is set by a European directive called MiFID II, and currently it is not still in effect. We're still living in a world governed by MiFID I, but MiFID II, its current date of implementation has recently been moved from January 2017 to January 2018. Meaning that MiFID II will actually come into force likely during the 2-year exit period, which promise to be an interesting issue to deal with. Second thing I will add is that I share John's view that it is likely or almost inconceivable that the UK would not be regarded as equivalent to European law. Now, after a few conversations with regulators over the last days here, it seems to me that conditions for recognizing equivalency to foreign law under MiFID II is not only dependent upon similarities between this foreign law and EU law, but almost identical in every material respect, and this is likely to be a very high requirement. Second, there need to be a full reciprocity, meaning that European institutions will have to be given equally a free access to the UK. But that's the only two things that I would mention at this point.
Okay. Thank you, Alban. Claudia Leindecker in Germany, in Dusseldorf. Could you comment on all of that from the German point of view, and perhaps noting some of the comments that we've heard coming out of the summit yesterday and today in Brussels?
Well, I'd like to start with any views of the German regulator. There has been no formal communication on Brexit by the German regulators yet. So while the UK remains in the EU, nothing should change. Moreover, the German Chancellor Angela Merkel said in a statement yesterday that the EU will not even be starting initial talks with the UK before the UK has given its Article 50 notification. So we would not expect any guidance from the German regulators until at least then. Thereafter, the attitude of the German regulators will obviously depend on the nature of the negotiated arrangements the UK reaches with the EU. Angela Merkel has said that they will not allow any cherry picking in the negotiations, i.e. that the UK cannot expect to continue to have all the privileges of EU membership without having to comply with any duties. So from a German side, we would say that UK passporting is not necessarily dead, but it will probably have to come at a price for the UK, as we've already heard. And there the question is whether the UK is willing to pay the price.
Okay, and so that's exactly the kind of point that we were hinting at when we were very briefly talking about the Norway solution as a means of gaining the UK continued access to the single market right up at the beginning of this conversation. Thank you, all of our banking team all over Europe. Still slightly on the banks, on that question of these suggestions that the banks may be about to relocate from London into Europe. We have been hearing a lot about how EU nationals at those banks and elsewhere might be required to go back. I would say about a quarter of the parents at my daughter's school are EU nationals, and that's certainly been concerning them. Mark Taylor, are they all going to have to go back if there's a Brexit?
I think, John, that's an outcome that nobody really foresees as happening. It's almost inconceivable. A couple of reasons for that. First is that no country has ever been access to the single market without allowing full freedom of movement of people across borders within the EU. Second is that since the referendum on Thursday and the result on Friday, all the leading members of the Leave campaign have been at pains to express that this was never something that they were campaigning for. And finally, you've got the practical issue that 3 million people from the EU live and work here, and repatriating that number of people would cause a huge number of practical problems.
And I'd actually put it rather stronger than that, and say that the UK generally and London in particular would almost certainly cease to function without those 3 million EU nationals that are here. Okay, and then I asked the same question of John Ahern in relation to bank regulation, but in the event of a Brexit, is the UK going to decide to change all of its employment laws?
Well, I think the final shape, if we are to exit the European Union, the final shape of employment law will depend to a significant degree on politics at the time. But if I give you the 30,000-foot summary about what that shape is likely to be, I think there'll be comparatively little change. And there are a couple of reasons for that. The first is that a lot of our key employment laws predated our membership of the then Common Market, now European Union. So things like unfair dismissal, sex discrimination, equal pay, race discrimination, they were all in place before we joined the EU. We also introduced things like disability discrimination law well ahead of any EU directive on the subject. So that's a key thing to remember. The second thing, I think, is that even in relation to a number of EU directives, in our implementation of them, we've gold-plated those in English law. So, for example, our maternity rights are much more generous than the directive. And other laws like minimum annual holiday and the transfer of Undertakings regulations, we have given enhanced employee protection well above the EU directive levels.
Okay. Just for the benefit of our listeners outside of Europe, do you just want to explain what we mean by the transfer of Undertakings regulations?
This was a directive around 40 years ago coming out of Europe, which was meant to equalise the rights of employees in an asset transfer with those who would have the shares of the company in which they were employed sold. The idea was that they would be transferred automatically to the buyer. We have, in the UK, substantially augmented that so that it now applies to franchising outsourcing in a way that some of the European other member states have not done. So we've gold-plated it to a significant degree.
Okay, great. But is there anything that might go? Are there any employment rules that might be repealed?
as I said, I think the core will stay intact. What we're looking at is things around the fringes, so some of the consultation rights around European Works Councils within the transfer of undertakings legislation as well. They might go, they might be vulnerable. Agency worker protection, probably vulnerable because it's not very popular. And one or two other aspects of European case law, I suspect, will be legislated against, but the core will remain.
Okay, thanks, Mark. Can we look at tax now? And Blaise Marin, who heads our tax practice in Europe. Multinationals. We've been hearing a lot in the last couple of years about the tax arrangements of multinationals in Europe. But are they going to have to look again at their tax structures if the UK leaves the EU?
It's just too early to tell, I think. We've only just voted for Brexit, and then there's a substantial number that seem to want a re-entry now. So what I can say is that there was a substantial body of EU law that made the UK an attractive hub for investment into EU. And you would have to say that in a Brexit scenario, that body of law will cease to apply. We do have, in the UK, tax agreements with most member states of the EU, but they're not perfect. And they may well have to be renegotiated. So I think at the moment, the best thing large groups can do is monitor the progress of the Brexit negotiation, and we'll be updating clients regularly.
Okay, thanks. But generally speaking, no change for now?
I don't think so, no.
Okay. Now this, I'm sure, is going to be wishful thinking, but putting to one side the UK government's funding requirements, if the UK left the EU, would we be able to say goodbye to VAT, which is always over here considered to be a European tax?
Well, I'm afraid the news is bad there, because I think there is no scenario in which the UK will not have a VAT system. What we can say is that the administrative arrangements that underpin the VAT system in the member states is extremely complex, and it's really at the heart of the Brexit negotiation, because what it's all about is free movement of goods and free movement of services. So we will have a VAT. I don't know how the administration arrangements are going to work. And again, the best thing people can do is just keep a weather eye for developments, and we'll be updating people.
Okay, thanks, Blaise. Can we go back to Harriet? Companies operating in Europe are obviously extremely keen to make sure that they comply with all of Europe's laws, not least corporate criminal laws. So in areas such as money laundering and sanctions, again, would there be any change?
So I think of all the questions you've asked, that's actually the easiest one to answer. Nothing changes as a result of the referendum, and even if the UK were to fully leave the EU single market, nothing would automatically change in either the AML or the sanctions regime in the UK. The UK generally has strict standards. They often go beyond the minimum EU standards. As Mark says, if we have English law gold plating for employment law, we probably have titanium plating for AML. So no change now, no change in the future.
Okay, thanks. Matt Evans and Alan Davis, in antitrust and regulation of, if you like, the behaviour of companies in the UK. On a Brexit, would there be less red tape for business? We've heard a lot of suggestions that there might be.
Well, John, I'm smiling because on antitrust, it's probably bad news for business and pretty good news for lawyers. We certainly expect more red tape in the event of a Brexit. First up, it's worth noting, I think, to everyone that we already have UK competition laws in place and they mirror EU competition rules. So the rules on cartel, the rules on anti-competitive agreements and on abuse of dominance won't change if the EU leaves if the UK leaves the EU, certainly not for some time. What will change is that where there is, for example, a Europe-wide cartel affecting trade both in the UK and the EU, not only is there likely to be an EU investigation by the European Commission in Brussels, as there is now, but post-Brexit, the UK Competition and Markets Authority
could also start a parallel investigation. And the same applies to merger control. The loss of a one-stop shop approach where the Commission would do one investigation covering the whole of the EU will also extend to cross-border mergers where businesses may find themselves having to make a parallel merger filing in the UK as well as at an EU level in Brussels. So that means more meetings, more documents, more strategizing, greater risks. So the net effect of all that is that we expect more investigations, more notifications, and I'm afraid more red tape for business.
Okay. That is bad news indeed. Alan Davis, whenever we have a major business in difficulty here in the UK, and we've had a couple of examples of that recently, there's always, a cry always goes up that the government should sort it out, the government should fix it, and of course we all know that it's not as simple as that because of the rules on state aid. In the event of a Brexit, would the UK be freed from those rules?
Well, John, I think those that voted leave might be disappointed. I mean, we saw recently the example of the steel industry in the UK, where the government came under a considerable amount of pressure to step in and save jobs in what was considered to be a strategically important industry. And I think we will, of course, expect to see much greater pressure on UK future governments to subsidise these strategic industries, and also potentially to attract greater inward investment from international businesses by offering them tax breaks. And of course, up until now, the government's been able to fall back on the so-called EU excuse that the state aid rules stop them doing anything. But the reality is that whether anything will actually change will depend on the deal that's done with the EU. The Commission President said today that anyone wanting access to the single market would have to adhere to strict criteria without exception. I think state aid rules are unquestionably going to be one of those areas where the UK will be expected to continue to comply with the existing regime. And, even if they don't do so, the UK remains a member of the World Trade Organization, and there's a set of rules against subsidies there anyway.
So we keep hearing again and again, no cherry picking, and we are a member of the World Trade Organization anyway. In a similar vein, will after a Brexit, will national government in the UK and local authorities, will they be able to favour UK suppliers when awarding contracts?
Well, I think it's the same story. I mean, the current system that we have, the so-called public procurement law regime, means that all companies from across the EU have an equal right to bid for each other's national contracts, and in the UK that's quite a considerably lucrative UK public sector. And those who favoured Brexit hoped for a watering down of those rules so that UK businesses could win more UK contracts. But again, in the same vein, in reality, if we end up staying in the single market or having access to the single market, it is very likely that we'll end up having to comply with the existing sort of type of public procurement regime.
Okay, thanks, Alan. So that's a quick trot through various areas of general regulation. I'd like to look now at specific industry and sector regulation with the help of Bernard Amery, who is in our Brussels office, the epicenter of political Europe, and who is a great expert in industry regulation. So, Bernard, could you talk to us about the issues in, for instance, telecoms, where I know the individual consumer is always concerned about roaming charges, energy, pharma, chemicals. Could you give us a quick whistle-stop tour through the issues in those industries?
Yes, good afternoon from Brussels, where another European summit just finished. And actually, as we speak, President Tusk and President Juncker are holding a press conference down the street. But this morning, the summit was without our British friends for the first time since 1973. But the industries that John just mentioned are indeed regulated at the EU level, too heavily regulated, some would say. But from a legal standpoint, one must distinguish between EU regulations and EU directives. And EU directives are implemented by way of UK legislation, and this national legislation, although based on EU directives, might not be affected by the Brexit. But EU regulations would cease to be applicable in the UK on the day of the Brexit. So for telecoms, for example, that means that as of that date, the EU roaming regulation would no longer apply in the UK. So for UK operators like Vodafone or O2 and the likes, they will be free to charge higher rates to the European operators for the use of their network in the UK by the travelers coming from the EU. And EU operators like Orange in France or Telefonica in Spain, they will also be entitled to charge more when British people use their mobile network and phones in France or Spain. And of course, this is subject to what sort of deal could eventually be reached between the EU and the UK, as others have mentioned on this call.
Okay. And do you think that those operators would be likely to do that?
Well, it will depend what the UK government will do, but obviously operators who have strongly opposed the EU roaming regulations would be very pleased to see it go in certain parts of Europe.
Okay, thanks, Bernard. And what would you look at next? Maybe energy?
Energy, the regulatory environment, the regulatory framework is also going to be affected in the UK. For example, just one example, the EU regulation on what is called market coupling would no longer apply in the UK. Well, what does that mean? Well, it means that the UK electricity companies will be excluded from access to the pan-European basket where all national power exchanges pool the electricity for cross-border trading. It's a mechanism that allows them to better match offer and demand on an EU-wide basis.
Okay, and I think I also said pharma, Bernard.
Yeah, pharma and actually also worth mentioning chemical sector. These are sectors which are regulated again at the EU level, and there are many pharma products available on the EU market for which the marketing authorizations were granted to UK companies. And the same is true for chemical products, which must be registered under the EU so-called REACH regulation in order to be sold in the EU. If the UK is no longer part of the EU, those marketing authorizations for pharma products and registrations for chemicals might need to be revised depending on what is eventually agreed between the UK and the EU.
Thanks, Bernard. We are all going to be watching the TV news tonight to see the Brussels summit with as much interest as we were watching it last night. So that will be fascinating. We've only got two more topics left that I'd like to briefly look at. The first is data protection, and there can't be a subject really that has aroused as much interest in the business world in the last couple of years as the capture of big data by big companies. Jonathan Little here in London is an expert on that. Will the UK be, if you like, independent of the EU from a data protection regulation standpoint if there's a Brexit?
Well, John, I think in theory, yes, but in practice the answer is going to be no. Whatever happens for Brexit, the internet and cyberspace won't stop at the end of the Channel Tunnel. So we need to consider how data flows between the UK and Europe. And the UK will have a choice. If it wants to have the benefit of a free flow of data, then its data protection laws need to be adequate, and that's assessed by the EU Commission. And there is a growing tendency in Europe to see adequate as meaning equivalent. And if you use the Swiss by way of an example, they have a very similar data protection law to that required by the EU. So we'll pick up the laws just by virtue of having this necessity for adequacy. If we don't do that, if we decide to go our own way, then we push the burden onto individual businesses. If they want to get data from Europe, they'll be in the same position as US businesses are at the moment. And they'll have to put in place one of a number of arrangements, something like the binding corporate rules, standard clauses, or a bilateral scheme like the Privacy Shield. None of that is cost-free, it's administratively cumbersome, and those very mechanisms are under challenge both legally and politically in Europe. So it's not a very secure approach. So we have that choice. Do we have the benefit of flow, in which case we have European rules, or do we push the burden onto businesses?
Okay, and looking the other way, will we be able to change the rules on data transfers to the US?
It's going to be a very similar answer. Between ourselves and the States, we could remove the restrictions. The problem is the methods that are going to allow transfer from Europe to the UK are going to include restrictions on further transfer. So again, we'll have the same or similar restrictions going forward.
Okay, thanks. Thanks, Jonathan. Right. Last, but very definitely not least, the intellectual property. The one question on which I've received most often in the last few days and weeks has been about the impact of Brexit on the unitary patent system, the proposed unitary patent system, and the proposed unified patent court. Alistair McCulloch here in London, could you just say a few words on that, and indeed on anything else relating to IP that takes your fancy in relation to Brexit?
Surely. At this stage, I think there's only one issue that is relatively sure, and that's that the new patent system for Europe, and it's going to comprise, as John indicated, a unitary patent that will cover most of the EU, together with a new cross-border patent court. And this had been expected to come into force sometime during the summer next year in 2017, will now almost certainly be delayed, and probably by several years or more. I think in the meantime, the current patent system in Europe will continue as it is today. And in this regard, it's important to appreciate that European patents, our current, what are called European patents, are not in fact derived from the EU, and the prosecution and the enforcement of European patents will be unaffected by any departure of the UK from the EU. Looking forwards, we have much less certainty on what will happen to the proposed new patent system. This is going to depend upon the negotiations and the developments over the next months. Much of the early commentary that we've seen since the referendum vote came out has been saying that the UK would be excluded from the new system. And this would certainly be the case on a UK exit from the EU under the existing proposals. But with the likely twists and turns ahead, it seems far from certain to me that this is the only outcome. Turning to trademarks and registered designs, on these rights, we already have EU-wide rights. And on the UK ceasing to be a member of the EU, these rights would no longer extend to the UK. However, it's very likely that the holders of these rights would have the opportunity to get a UK national right to exist alongside the EU trademark. And there is a general consensus amongst practitioners that the EU trademark owners are unlikely to be prejudiced in any way. Having said that, companies wishing to adopt a risk-averse approach, and that may be appropriate on seeking a new important protection for a new important mark, could apply for a UK trademark in addition to an EU trademark. One quick final point for EU trademarks. There is a need for these marks after the initial period to actually use the trademark. And for all existing EU trademarks where the majority of the use of the mark to date has been here in the UK, then to protect those marks going forwards, owners should look over the next year or two to ensure that they've got adequate use of those marks in the rest of the EU to make sure they've got the use requirement covered.
Okay, thanks, Alistair. So that's our planned agenda dealt with, and I'm pleased to say that I'm just going to say a few concluding words, but we've brought it in on time. The call, as I said, was designed to provide a brief insight into the key issues on which our clients are focusing. You will have seen, and I can't emphasise enough, that we're all going to have to apply further analysis to these topics as we see and as there is created a clearer route forward for the UK's new relationship with the rest of Europe. And until then, there's going to be an awful lot of speculation. We are going to be updating our website on a regular basis with details of further webcasts and calls, and we'll also provide commentaries on particular issues. And as I mentioned earlier, if you have questions on any of this, please do send them in either directly or via the Q&A section on the webcast website, and we will reply. To wrap up, I would just want to mention at this stage 3 business as usual messages regarding legal issues coming out of Brexit. First, nothing in English law has changed as a result of the referendum result, obviously. Second, we can't see a bonfire of red tape in a post-Brexit world. And third, the reasons for choosing English law are as strong as they ever were. We've been having, as you would expect, lots and lots of conversations with clients, and everything we're hearing is sanguine and rational. There's a feeling that common sense must at some point prevail, and I trust that you've got a sense of that from the comments that have been made today from around Europe. So the dust will settle, and London and the UK will continue to provide significant opportunities for investment. On particular issues, we can see an increase in shareholder activism, maybe a short-term decline in UK M&A activity, although that may well be partially offset by attractive pricing as a result of the exchange rate and the weakened pound. And there may also be an acceleration of alternative capital again to fill any void in traditional lending. And I'm sure there'll be many other themes that will emerge. These are very interesting times, to put it mildly. And we have the specialists here in London, across Europe and in the rest of the world, to help our clients with the challenges, yes, but also the opportunities that all of this is going to present. So I would just like to finish by thanking you all for joining us, and I hope you all have a good day. Thank you.